You know, as Pat just said, last Tuesday, the oral argument took place at the Supreme Court in the Hobby Lobby case. Actually, there are two cases. One is the Hobby Lobby case, which was decided in Hobby Lobby's favor by the 10th Circuit, which is a federal appeals court, I guess, in Denver. And the other case is the Conestoga Wood Specialties case, which raises basically the same set of issues that was decided against the company and in favor of the government by the 3rd Federal Appeals Circuit in Philadelphia. So these two cases were consolidated at the Supreme Court and heard together. And they raised the important question whether closely held family-run businesses can claim religious freedom from the requirement imposed by the government under Obamacare that employers provide free contraceptive coverage for drugs that can cause abortion. So as I said, the 90-minute argument was on Tuesday. 90 minutes is longer than the usual Supreme Court argument, so the Supreme Court gave it extra time. And one interesting feature of the argument was the two lawyers who were arguing the case were probably the leading Supreme Court litigators of our day. Paul Clement was arguing on behalf of Hobby Lobby and Conestoga Wood Specialties, and he had been Solicitor General, which is basically the Justice Department lawyer who argues before the Supreme Court, who handles Supreme Court cases. He had been Solicitor General under the George W. Bush administration, and his opponent was the current Solicitor General, who's Don Verrilli, who was appointed by Obama. Fortunately for us, I think the better advocate is actually Paul Clement. I mean, just in terms of skills. Yes?
Where is Hobby Lobby? I don't know.
Hobby Lobby is it's a chain of craft stores that is headquartered in Oklahoma. I guess it was founded there by the Green family, and but there are now over 500 stores around the country, including, we have them in Massachusetts as well, and I think they have 13,000 employees coast to coast. Actually, this came up in some ways at oral argument because, as we'll see, one of the issues under the Religious Freedom Restoration Act is whether the regulation of the federal government poses a substantial burden on the practice of religion. And the claim was made by, I think, Justice Sotomayor and joined in by Justice Kagan, that in effect, Hobby Lobby could avoid the problem of conscience by simply dropping health insurance altogether for their employees and paying the $2,000 per employee fine, which would basically amount to a $26 million tax or penalty, depending on how you view it. One of the interesting features of this, and therefore they could avoid having their conscience burdened. They just pay $26 million for exercising their freedom of conscience, and plus they would drop health coverage for their employees. At which point Chief Justice Roberts made the interesting point that part of the religious mission of this closely held family-run business, what it was precisely to provide health insurance for their employees, right? So anyway, as was stated, I guess I filed an amicus brief on behalf of Mass Citizens for Life and the Pro-Life Legal Defense Fund and a couple of other nonprofits, and I got a lot of help from, fortunately, in my dotage, from my law students, well, actually students both at my own law school and students at Boston College Law School who volunteered, and that Bob Joyce essentially put me in touch with. And my amicus brief argued in support of the companies that our legal history and tradition it argued, it was on sort of a matter of legal history, right? That was the angle of the brief, and pointed out that our legal history and tradition has often been, has illustrated the proposition that secular corporate charters have often been the vehicle for the practice of religion unhindered by government control. And actually, I've left outside actually a couple of handouts, which are, the 2 articles that I've written about this month. One was in the Boston Sunday Globe on Sunday, March 2nd, and the other was in yesterday's Boston Pilot, and also the New Bedford, the Fall River Anchor, I guess. But anyway, so I summarized the brief in this article, so I think I'll spare you going through the history. If you're interested, you can read about it, or if you have trouble sleeping some night, you can always pick it up. But I do think it is telling that Roger Williams, the founder of Rhode Island, favored a broad understanding of religious freedom. Received a charter from Rhode Island, and this is a corporate charter now, that stated, quote, "No person within the said colony at any time hereafter shall be in any wise molested, punished, disquieted, or called in question for any difference in opinion in matters of religion, but that all freely and fully have and enjoy his and their own judgments and consciences in matters of religious concernments." And not long after that, in 1658, the General Assembly of Rhode Island reinforced the validity of the charter and reminded the other colonies that, quote, "freedom of different consciences to be protected from enforcements was the principal ground of our charter, which freedom we still prize as the greatest happiness that men can possess in this world." Right? Showing the centrality, really, of religious freedom in this corporate charter, right, and of Rhode Island. And the same could be said of a number of the other colonies, to the point where, this tradition of religious liberty on these shores is like a glory of our history, right? It's in some ways we taught the world what respect for religious freedom means. Anyway, as I've said, the technical legal question before the Supreme Court is whether business corporations are persons within the meaning of the Religious Freedom Restoration Act, which was an act of Congress passed in 1993. And it's a federal law that applies to all persons, but doesn't expressly define person. Right? Now, from my perspective, and I think from the perspective of the company certainly, and their advocate, the Federal Dictionary Act is a law of Congress that is intended essentially to define terms in the federal code, right, in the United States Code, that are not otherwise defined. And if you look in the Federal Dictionary Act under the term person, it turns out that persons includes corporations, right? They're legal persons. Now, this is a long-standing legal fiction that dates back to the Middle Ages and even before, actually. It's in Roman law as well, right? This idea that a corporation, a company, can be considered, from a legal perspective, to be a person, which basically means that it can sue and be sued and act, in concert. And, just on the eve of the American Revolution, William Blackstone wrote his famous 4-volume commentaries on the laws of England, and the first volume is on persons. That is, it follows the standard Roman law order of dealing first with persons, then with things and property, and then with legal relations, right? So it starts with persons, and the last part is on corporations, because Blackstone says that corporations are artificial persons, right? We have natural persons, and one of the things he says about natural persons is these begin in the womb, right? Which is interesting.
when it suits.
But then, in addition to that, there are these artificial persons, right, which are, among other things, corporations. So, for example, churches were corporations, universities were corporations, and these were all recognized as legal persons. And anyway, so assuming, and to tell you the truth, I think this issue about whether at least closely held family-run businesses can claim to be persons under the Religious Freedom Restoration Act, I think it's pretty clear we're going to win that issue at the Supreme Court, right? That is, maybe it's 7-2, something like that on that proposition, because there are very troubling consequences with holding that corporations are not persons. And I suppose one of the things that Justice Kennedy actually brought out in oral argument, which I think is a very interesting point, is that it's actually, Congress is not the one who decided to apply this contraceptive mandate to for-profit businesses. This was done basically within the Department of Health. It was a bureaucratic decision within the Department of Health and Human Services, which essentially decided to distinguish between religious organizations, mainly churches, then religious organizations that are not for profit, like hospitals and universities, in which case there's a sort of accommodation. And this is what's at issue in the Little Sisters of the Poor case. And by the way, in addition to being the counsel of record for Hobby Lobby, Mark Rienzi is also the counsel of record for Little Sisters of the Poor, as well as for Eleanor McCullen and the group of heroic sidewalk counselors that have the case pending before the U.S. Supreme Court in the buffer zone challenge, right? So anyway, so basically it's HHS that has decided to distinguish between these three types of organizations and essentially say that for-profit businesses need not apply, for religious freedom, that they don't qualify, basically. Now, the point that Justice Kennedy brought up was that this line was not made by Congress. This is a line that was made by the administration, by the bureaucrats in HHS, led by Kathleen Sebelius. And the question is, where does HHS get off basically making the decision that for-profit businesses don't have religious freedom? It's not like this is a health issue, right? I mean, this is an issue really of constitutional law, of religious freedom, as to which HHS has absolutely no expertise and no mission, really, legally, other than to apply Congress's stated law on the subject, which is the Religious Freedom Restoration Act, which says that anytime anyone finds their freedom of religion, their ability to practice their religion substantially burdened, then the burden falls on government to demonstrate that it has a convincing, compelling reason or justification for so burdening their religion, and further, that the regulation is no more religiously restrictive than necessary to achieve this compelling government interest. This kind of explains, actually, I think if you think about this law and how much protection it gives religious freedom, it explains why it is that the government's principal argument was the law doesn't apply. This isn't a person. Because if you assume that the law applies, right, then you immediately get into the question about whether the grieved families and the corporations' religious freedom is being burdened, and you get into the compelling government interest, least religiously restrictive alternative analysis. And now, as to the compelling government interest, I think it's clear because the law and the regulation have so many exemptions, right? That is, it turns out that if the employer, and we're talking about the vast majority of employers in the country, have less than 50 employees, then they're not bound by the mandate, right? So they're exempted. So you have all the people that they employ that are not going to be covered by this mandate, the contraceptive mandate.
Plus, there's an exemption for grandfathered plans, which basically means any company that has an existing health care plan and doesn't make changes to it doesn't have to provide coverage. Plus, you have the ones that the HHS recognizes, the churches, right? So my point is that if the government's interest in providing, let's say, emergency contraceptives is so, that is, if it's so important that everyone have free access to emergency contraceptives, even, right, then why are they exempting, I don't know what the total amounts to, but a very significant portion of the population from this requirement, right? In other words, if it's so important, how do they get off exempting all these groups, right? So it shows that it's not that important, actually, I think. You know, I guess it was the Wall Street Journal the other day in an editorial about, you know, one of the things about the whole Obamacare thing, right, is that there have been these incredible waivers from the law granted by the administration by executive order and decree, right? But just, you know, dozens of these things along. So that, you know, at a certain point, the only mandate, you know, the only part of Obamacare that's still kind of in force is forcing the Little Sisters of the Poor to provide, you know, contraceptives. I mean, but anyway, so there's this problem with compelling government interest. But even assuming that there is a compelling government interest, how is it that the least religiously restrictive way of providing free emergency contraceptives is by forcing people who are religiously and conscientiously opposed to it to do it, right? Why doesn't the government, if it's so damn important, why doesn't the government do it itself, right? Instead of forcing people, dragooning people into doing something against their religious conscience. I mean, there's something really fundamentally kind of illiberal and un-American about this, right? It's sort of forcing people to do what they're religiously opposed to. I mean, the founders and framers, one of the things they did, it's very interesting, you know, if you look at the first generation, Quakers were exempted from military service, right? I mean, military service was considered quite important, right, just for the defense of the country and so on. But there was a sense that Quakers are pacifists, and therefore we can't force them to do something that violates their religious conscience, right? It's just wrong. So that's, you know, that's a long-standing tradition. The thing that I thought was kind of interesting, and actually I deal with this in the piece that was published yesterday in the Boston Pilot. It's in response to my article in my op-ed in the Boston Globe. There were 3 letters published the following Sunday, and basically making arguments against the position of the corporations and in favor of the government, right, in this Hobby Lobby case. For example, a person who calls herself, quote, a reproductive health advocacy fellow with Physicians for Reproductive Health. So we get reproductive health twice in the same phrase, right? You know, okay, we get the idea. But of course, reproductive health is a euphemism, I think, for other things, but in any case, it's really non-reproductive we're talking about, right? I mean, which is why they're sort of protesting too much that it's reproductive health, you know. Anyway, she writes, quote, as a physician specializing in family planning, I am outraged when I see news outlets publishing misinformation about contraception, unquote, referring to my piece. She's outraged, right? Because this is misinformation about contraception. The good doctor categorically states, quote, no method of birth control causes abortion, period. So the issue is whether any forms of contraception can cause abortion, right? I mean, that's what she's put into question. Well, she reports that, and this is, I'm quoting from her, quote, contraception, including emergency contraceptive pills such as Plan B and Ella. Plan B, by the way, this is my paraphrase now. Plan B is the so-called morning after pill. Ella is the so-called week after pill. But getting back to her quote, contraception, including emergency contraceptive pills such as Plan B and Ella, work primarily before fertilization occurs. They do not work post-implantation and do not disrupt an established pregnancy. Notice the words primarily and post-implantation and established pregnancy. They are a tacit admission by the letter writer that emergency contraceptives secondarily work after fertilization to prevent implantation of the fertilized embryo in the womb. So without doublespeak, that is an abortion. That is an abortion, which is the issue for the Greens, the owners and directors of Hobby Lobby, and what they object to, since they do not object to other forms of contraception that do not have an abortifacient feature. There's more to this whole question than I think I've indicated, in the sense that I think there's been a concerted effort on the part of the reproductive health crowd to essentially redefine abortion, right? So that, in effect, by definition, flushing out a pre-implantation living human embryo and thus killing it is not considered an abortion, okay? But this is, I don't know, the worst kind of Orwellian doublespeak, right? But it's interesting that this came up actually in oral argument because a number of physicians groups and, the New York Times last Sunday in its editorial basically said that the Green family's view that these 4 techniques of contraception are abortifacient was incorrect. It was incorrect, right? They're wrong, in other words. It's like they're wrong as a matter of sort of scientific fact, right? Which is total bullshit. I mean, it's, and furthermore, there's an interesting legal answer to this, right? Which is this. Although I think it's important to fight this point because I think it's fundamentally dishonest on their part. They are clearly trying. It's a wordplay game, right? They're sort of playing with the meaning of words to make it seem that, I don't know, that the IUD cannot cause abortion, right? Which it can, which it can. But the legal answer is this. From the standpoint of the First Amendment, the First Amendment begins, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. What this means, and what the Supreme Court has said the Establishment Clause means, right? So-called separation of church and state. What it means is that it's not the job of government to be determining the truth or falsity of religious beliefs, whether they're correct or incorrect, reasonable or unreasonable. That is not a matter for government. That's between God and the human conscience, right? It's not a matter for government, meaning that the only inquiry that government can make about a person's religious belief is not whether it's true or false. It can only ask whether it's sincerely held, right? In other words, whether the person really believes it. That's okay. And my point is, the government has conceded time and time again in this case, and in other cases, that the Greens and Hobby Lobby have deeply held, sincere religious beliefs. So my point is actually that, even though I think it's important to fight this issue about, the truth or falsity, what I'm saying is it's legally irrelevant, right? Because clearly and conceitedly, the Greens are sincere in their religious belief. And that's all that's needed, right? To invoke the Religious Freedom Restoration Act. So anyway, I guess I do think that contrary to what the reproductive health care advocate said, that some forms of contraception can cause abortion, right? And the fact that this happens to outrage the reproductive health advocate, from my perspective, that's just a perk. Anyway, the other two letters that took issue with my article both raise in different ways the claim that the relevant religious freedom at issue here is not that of the employer, it's that of the employee. But consider what's at issue, which is the regulations under Obamacare. They're not requiring employees to use or refrain from using contraceptives that can cause abortion. That is, employees can do whatever their religion, conscience, freedom, pocketbook permits. But the contraceptive mandate is requiring employers to provide abortifacient contraceptives free of charge, and thus to cooperate in doing what they regard to be religiously prohibited and evil. And so the relevant religious freedom in these cases is that of the employer, not the employee. From the employer's perspective, if it's your body and your choice, why should I have to pay for it if it runs the risk of killing a human embryo? So that's pretty much what I have to say, but maybe there's some questions, objections, I don't know. I'm open to that. Yeah, Henry.
Getting to the legally irrelevant part of what you're saying. In 1966, the American College of Obstetricians and Gynecologists changed the definition of pregnancy from fertilization to the implantation of the fertilized ovum.
Right.
And primarily that was to enable Delcon shields and IUDs to be dumped on the third world.
Right. No, I think that's right. I think that's right. And this came up in the oral argument the other day. They say 2 million women in this country use IUDs, right? So basically, we can't, it has to be a contraceptive, and it can't cause abortion, right? Because you know what I'm saying? It's just as a public relations disaster, kind of, if the truth is known about the effects of this. Yes?
Do you think the ideological benefit, Sotomayor, others, Kagan, do you think that this has a chance, for instance, we were so disappointed with Roberts regarding Obamacare? Everybody said somebody must have something on Roberts, that he would flip his writing, and he flipped.
Yeah, I think there's no question, but on the merit, as I said, I think my own prediction is the Supreme Court is going to rule in favor of Hobby Lobby on the question of whether they're a person and can assert religious freedom. Another issue, though, once that's established, is the issue of whether they win on the merits under the Religious Freedom Restoration Act. My sense there is that's a closer question, and that Kennedy is actually the swing vote. I honestly think Chief Justice Roberts is going to be solid on this one. I think the one to worry about is Kennedy, which is never a good situation to be in, from my perspective, although I think, if I was predicting, and I certainly hope he will rule our way, in which case it will be 5-4 upholding the companies here. So we'll see. I'm not confident of that, just because, I've been disappointed in Kennedy a number of times. But, that would be my sense of it. One of the unfortunate things that's happened in this case is that the Supreme, I had hoped this would not happen, which is the Supreme Court is approaching this case politically and ideologically, so that there is this 5-4 split, right, one way or the other. The reason I say that is, when the Religious Freedom Restoration Act was passed 20 years ago in 1993, it was unanimous in Congress, and all but 3 of the senators voted for it. In other words, the support for it was overwhelming and bipartisan, right? And President Clinton immediately signed it and enacted it into law, right? So what I'm saying is something has happened since then that makes religious freedom a kind of divisive, political, ideological football, which is very unfortunate, actually. And in fact, 2 years ago, interestingly enough, the Supreme Court was faced with another religious freedom case in which the Obama administration was claiming that federal employment discrimination law should apply to religious schools, such that if they decide to fire a teacher, right, the teacher can raise any one of a number of, claims of discrimination, right? Discrimination on the basis of disability, discrimination on the basis of age, discrimination on the basis of gender, or what have you. That was the position of the Obama administration. The case went to the U.S. Supreme Court. The claim was that since the woman who was fired in that case taught religion at a Lutheran school, the claim was made that she was a religious minister and therefore was entitled, there was a constitutionally required exemption from employment discrimination law for religious ministers. And the Supreme Court, including the two Obama appointees, unanimously decided that there was a constitutional exemption from religious discrimination law, when it came to teachers of religion, ministers of religion, and so on. In other words, it's not for the government to say who can teach a religion and who can be, a minister in that religion. That's for the religion to decide, right? So that was unanimous. But what I'm saying is, because of whatever, just because of, I guess, partly because of the poisoned political atmosphere in Washington, this has had an unfortunate spillover in the courts, and so this case is a lot closer, I think, in practice than I would have liked. It should, to me, I don't know, religious freedom is one of these sacred cows. Really? I mean, it should be a sacred cow, right? And therefore there should be relative unanimity on the question of respect for religious freedom, right? But that's one thing on which Americans should agree. It's certainly something that we can be proud of in our history. I mean, there have been obviously instances in which religious freedom has not been respected, but I think we tend to view those as, things to be embarrassed about and apologize for, rather than to be proud of. Whereas we are very proud of our tradition of religious freedom, I think, in this country, rightly so, because we were the first country in the world, really, to recognize religious freedom. Rhode Island, I think, was the first place in the world to, in effect, allow everybody, regardless of their religion, to have full civil rights. John Locke, who's one of the masters of the Enlightenment, inspired to a great degree our constitutional framework. I mean, he believed in freedom of religion, but not for Catholics and not for Muslims, right? And not for atheists. But Roger Williams, God bless him, was in favor of religious freedom for everyone, and in fact, in Rhode Island, that was the case. So it's not surprising we have. I think it's the oldest synagogue in the country is in Newport, Rhode Island, because the Jews felt, that they were safe in that kind of environment. So anyway, any other questions? Yeah.
If we do get that split decision, where does that leave those companies?
Well,
They said yes on one side and no on the other, so they're left sitting in the middle again.
no, I think they're going to decide both cases the same way. I mean, I think it's basically the same thing. I think, like I say, my prediction is we're going to win. If we don't win, right? If it's 5-4 the other way, then Hobby Lobby. It's one of the strange features of Obamacare in this regard is, the penalty on Hobby Lobby for dropping health coverage totally is $26 million. But if they tried to maintain health care but still refuse to provide the morning after pill and so on, the penalty then, the tax then, would be more than $500 million, right? So think about it. There's something, in other words, there's the way that the law is structured, it's essentially, if you're not providing the full package of what they think you're supposed to get, no matter how immoral and how awful it is, right? Then we prefer that you get out of the business altogether so that government, so essentially you're going to have to get your health insurance through the government on the exchanges, right? I mean, I don't know, it's a terribly draconian thing. So that would put Hobby Lobby out of business, right? $500 million is nothing to sneeze at, I don't think. Yeah, that's the other thing. Yeah, that's the other thing. It's a recurring charge, whereas dropping it is just a one-time charge. Yes?
It's my understanding that predating what the obstetricians and gynecologists came up with, implantation being the beginning of life, it was a committee from the National Institutes for Health that determined that among the only scientist on that committee was a geneticist, and unfortunately, on that committee was a Catholic priest, as well as Peter Singer, who thinks, from Princeton, who thinks it's okay to take the life of a child up to the year 2 years old, and other crazy things that he observes. I don't remember who the other person on that committee was, but it was the National Institute for Health, and the gynecologists and obstetricians jumped on that because it could allow them to continue giving out contraceptives or the pill, or unfortunately even Catholic physicians. So just an observation.
No, I think that's right. Anyone else? Yeah, Bob.
Dwight, do you think that the decision in these cases might have any impact on other issues involving the exercise of religious liberty in our country?
Well, of course, I think to the extent the court adopts a fairly restrictive interpretation for the Religious Freedom Restoration Act and thus of the free exercise clause under the First Amendment, I think that's not a good sign, because I do think that the secularist crowd is getting more and more aggressive and assertive, right? And unless some limits are put to their ability to kind of push back, I think, fortunately, we do have a long, rich tradition of religious freedom. There hasn't been, open religious persecution. We haven't had martyrs in this country in a long time, right? But it's not, the point is, I think that the move in that direction has to be nipped in the bud, right? Because that's the direction we're headed in, right? I mean, I remember reading this thing that the Cardinal Archbishop of Chicago said, right, that he, expected to die in his bed, right, but that, he thought that his successor might actually end up dying in jail, right? So, and obviously, the challenges to religious freedom here are nothing compared to what they are in parts of Africa or the Middle East or whatever, where people are killed just for going to church, right? But it's frightening to think what could happen if we're not, if we're not vigilant. Oh, yes, please.
I think it is time that we should be modest for our religion. And I think we should pray and fast, because that's the only thing that's going to save us, because it doesn't look good.
Yeah, I agree. I don't think it looks...
Sorry, but it doesn't look good.
Right. I agree it doesn't look good. On the other hand, I think my sense of it is, a person should be ready to be a martyr if necessary, but hopefully it's not necessary, right? I mean, I think if you look at the life of somebody like Thomas More, clearly he did not seek the confrontation, right? They came after him, right? So anyway, well, thank you. I'm sorry.
Do you think the Hobby Lobby side made better arguments in the case than the opposition side?
Yeah, very much so. I mean, I think Paul Clement is really the top Supreme Court litigator of our day. Unfortunately, he's on our side, and he's very quick. He's very good. One of the things that came up right from the get-go of his argument was Justice Sotomayor. He was like in his opening sentence, and she immediately said, "Well, what about if a company has religious objections to paying for vaccines or blood transfusions and so on?" So she immediately got onto this sort of slippery slope, which is if we recognize your right to back out of these, procedures that you find religiously objectionable, where can we draw the line in the next case, And Clement basically said, well, each case has to be considered on its own, which I think is correct. But one interesting point is, you know, the Religious Freedom Restoration Act was actually declared unconstitutional by the U.S. Supreme Court, but only as applied to state and local laws, not as applied to federal laws. So it still clearly applies to federal laws and federal regulations, such as the HHS mandate, right? That's a federal regulation. But in the case where the Supreme Court essentially applied the Religious Freedom Restoration Act at the federal level, it's called a case called O Centro. There, the Supreme Court basically said that the Religious Freedom Restoration Act requires us to examine the party before us and their particular claim, right? And what the government's compelling interest is in forcing that particular person. So my point is, in effect, that statement by the Supreme Court of the law in this area means actually the slippery slope is left for another day, right? In other words, let those people raise that claim at the appropriate time. What they have to do is balance the person's claim to, you know, having their religious freedom burdened against the government's compelling, least restrictive way of meeting its interest, right? So I think that's interesting. Plus, the other thing, and this is the way the argument ended, with Justice Kennedy bringing up, and Paul Clement reminded him of it in his closing words, in his closing argument. Basically, Justice Kennedy asked, well, what would prevent, would the Religious Freedom Restoration Act prevent the government from requiring, say, healthcare providers to provide abortions, right? To do or provide abortions. And the Solicitor General didn't have a good answer to that, which was, his answer was, well, they don't do it now, you know, there's conscience protections in federal law, right? But the point was, he didn't have an answer to that. So there's a slippery slope on both sides here, right? And I think clearly Justice Kennedy was concerned about this. Of course, Chief Justice Roberts had this very interesting colloquy at oral argument, where he asked Verrilli, the Solicitor General, to describe what it is that these contraceptives that are objected to do, right? And then he had to get into the, essentially, well, the possibility that they cause abortion, right? So he said, in effect, the government is already requiring, right, that you provide an abortion, right, through these regulations. So I thought that was interesting on Justice Roberts, Chief Justice Roberts' part, because I think he's very solid in this case. So we'll see. Yes.
When they decide at the Supreme Court already that it was a tax?
Yes.
Rather than,
that was 2 years ago. Yes.
Yes.
In the individual mandate case. Yeah.
Now, can they determine that if it is a tax, can they put a tax on people that makes them go against their religious beliefs? I mean, can you put a tax?
Well, no, I would say you can't, but I think it gets a little more. It gets a little more complicated, right? You get into this on what's called the unconstitutional conditions doctrine, which is when government can condition, you know, essentially, if they're penalizing the exercise of your religion by making you pay a tax for it, clearly that would be improper, right? So.